We'll call the hearing to order. A few things that we have, I want to address to you. There will be no approaching the board. There will be no note passing to the board.
I got it.
I want you to all remain in your seats in the audience unless you're testifying or you're leaving the room. I don't want any talking in between you so that we're able to hear everything. I have invited Commissioner Nelson to join our meeting due to the fact that he's on the Planning Commission and he is in the paperwork that was sent to us. David Anderson, Sonia Pino, and Roger Scarba were also on the board at that time, but they are no longer on the Planning Commission, so they will not be at the meeting. So, Commissioner Nelson, would you like to join us?
Madam Chair, I will sit wherever you would like and answer whatever questions I may to help you.
Do you want to come back around here then? And if you need the opportunity to answer the county business, you are free to do so. With that, Aaron Dean, are you in the audience?
I sure am.
Could you give your name and address for the record, please?
Aaron Dean, 5900 Mount Normandale Drive, Bloomington, Minnesota, 55433.
Thank you, sir. And I'd like to ask you, you say you represent the Friends of Fredenberg, LLC?
Yes.
Do we have any kind of a list, any kind of membership, any kind of officers who are in this Friends of Fredenberg?
No, and that information was not requested either. That is being discussed in the civil laws.
Because I feel that this is an anonymous complaint because we have no idea who you are representing.
I can assure you it is not anonymous. There are many citizens who are members of the LLC who have given financially, and some of them are very intimidated by this process. So they don't want to be public. But that's a topic for another day.
Well, I assure you sometimes I'm intimidated by the things that have been said about this board, but we are still here. And our names are in.
And I can assure you I will say nothing that's intimidating to anyone. I'm here to have a conversation with the board, and I look forward to having the opportunity to address you.
And Nick, there's a presentation before we get started.
I don't know if I call it a presentation, but just a little framing that might be helpful for the board. We are here for an appeal that's been brought by Fredenberg, LLC. It is a limited liability company that exists, was duly formed under Minnesota law, so it is a legit entity. Their appeal relates to the gravel pit located at 6464 Fredenberg Lake Road. And this is the second appeal that's been before the board with respect to that property. The first one was brought by Ms. Bell, and it was considered and decided by this board in May of this year. The one thing that I want to point out, after we turn the lights back on, is
I don't think you didn't realize it.
The appeal by Friends of Fredenberg involves 8 items, as you can see from the staff report and the other materials that have been presented. 4 of those items were considered and decided by the board in May. And in particular, I'm talking about item number 3, which relates to entrance gates. Item number 4, which relates to setback from wetlands. Number 5, which relates to the question of vegetative screening. And also the last item, number 8, which relates to reclamation. So those 4 issues overlap with the appeal from May. The remaining 4 issues are new issues that were not part of the appeal. Now, I mentioned the overlap just so you're aware of it. It's not the case that you have to make the same decision now that you made on those issues back in May. the information that's presented to you today might be different from the information that was presented to you in May on those issues. And of course, you're free to, and you should, consider the information that's presented at this hearing in deciding those issues in the context of this appeal. But when you hear Mark, a lot of the things you're going to hear today are the same as what you heard, and he's not because he's glitching out or anything, it's just because of that. So I just wanted to point that out before we do.
Does anyone have any questions for Nick?
Wait, I got a question. We've got 2 documents that were dropped on our desk. Who are these documents from?
That was from the friends of Fredenberg. There's some information they said that we didn't supply that they wanted you to have copies of.
Thank you.
Okay, thank you, Nick. Mark, you may proceed.
Good morning, and again, we're here to review the request for appeal by the Friends of Fredenberg. Basically, it's an administrative determination dated back to October 31st, 2022 by Matt Johnson, the St. Louis County Planning and Community Development Director, regarding the operations of the permitted borrow pit at 6464 Fredenberg Lake Road. It's the All right, so some background, and everybody should have received this in the report, but I'll just go through it so you keep it in your mind and for the people in the audience. May 14th, 2020, the borrow pit received CUP approval. June 12th, 2020, CUP permit was issued. September 16th of 2022, request for an administrative determination. October 31st, 2022, administrative determination sent to Elise Rat, I don't even want to, I'm going to butcher the last name, Radage, regarding the formal complaint. And then December 16th, 2022, there was the appeal of the administrative determination. Next slide is basically the zoning of the property. Next one is their site map, kind of showing where they're proposing to do their excavation of phase 1 of the borrow pit. We're going to get into the facts and findings, and I'll try to kind of bullet these a little bit so you, I'm sure you guys have all this in your report. The first request relates to the septic system on the subject property. Determination, the CUP provides the applicant shall adhere to all county regulations. This includes St. Louis County Subsurface Treatment System Ordinance. In July of 2021, we issued a notice of non-compliance with respect to this ordinance. An application to construct a new system was submitted and approved. In June 2022, once installation of the new system was completed, we inspected the new system, concluded that it was in compliance, and issued to the permit holder a notice of compliance to that effect. The permit holder has been in compliance at all times since then. For the avoidance of doubt, at no point in the process did St. Louis County determine that corrective steps were not possible or the permit holder was unwilling to take such steps. The ordinance, St. Louis County Ordinance 62, Article 3, Section 3.6 states a sanitary review shall be completed on all land use permits issued within the shoreland area, and parcels less than 2.5 acres shall have a sanitary review to determine if proposed land use permits would adversely impact the existing sewage system or expansion area. Facts. The permit holder is in compliance as it relates to SSTS ordinance. The home was not within the shoreline area or on a parcel less than 2.5 acres. The CUP was for a borrow pit with no request to generate additional wastewater. And the last one, septic permit 21S01629 has been issued, and you guys have receive the copy of those permits. The second request relates to the width of an access point as of October 2021. Determination, Article 4, Section 6.22 G12 of the zoning ordinance states, all accesses to public roads shall be approved by the appropriate road authority, but does not expressly address the issue of road width. In this case, in April 2022, the St. Louis County Department of Public Works, the appropriate road authority, approved a permit for a haul road with a 40-foot width. Based on review of aerial imagery of the property, the permit holder is in compliance with the 40-foot requirement. The permit holder is in compliance. Ordinance, number B, ordinance, basically go back to St. Louis County 62 Article 6, Section 6.22 G12 states that all accesses public roads shall be approved by the appropriate road authority. Facts, St. Louis County Public Works Department approved a 40-foot access permit, and the number is there, 2020-0936. Next slide shows the access road, which is less than 40 feet wide, which would be within the parameters of the permit. Facts and findings. Again, the third request relates to gates. Determination, Article 6, Section 6.22 G14 of the zoning ordinance states, an extractive use shall have a gate for controlling access. The use of cable chain or similar barriers is prohibited. This provision applies only to access points used for the extractive use activities. It does not apply to other access points. Although the subject property has multiple access points, only one of them, the haul road that enters the property from the south, is used for extractive use activities. Based on the evaluation of the subject property during an inspection conducted in 2022, the permit holder is in compliance. Next one is the actual standard of the ordinance. Basically, Ordinance 62, Article 6, Section 6.22 G14 states an extractive use shall have a gate for controlling access. The use of cable chain or similar barrier is prohibited. Facts, based on the evaluation of the subject property during an inspection conducted in August of 2022, the permit holder is in compliance with this condition in the CUP. A gate is located on the main borrow pit entrance that was granted through an easement and was approved by the Planning Commission and Public Works Department. Other access points are not being used per CUP approval and are not required to be gated. And if you look at the last slide, you can see where the gate is on the haul road. Facts and findings. The fourth question relates to setbacks from wetlands. Determination, Article 6, Section 6.22 G9D of the zoning ordinance states a no disturbance setback, including a haul road, shall be 50 feet from the boundary of a wetland. Based on the evaluation of the subject property during an inspection in August of 2022 and review of aerial imagery of the property, the permit holder is in compliance. Ordinance 62, Article 6, Section 6.22 G9 requires a no disturbance setback of 50 feet. Facts, based on the evaluation of the subject property during an inspection in August of 2022, a review of other aerial imagery of the property at the time of our review, and the permit holder is in compliance with the CUP. Basically, vegetative removal from the wetland averages 50 to 100 feet. Permit holder has not engaged in any observable activity within 50 feet of the wetlands, and the haul road is approximately 230 feet from the wetland boundary. The next one relates to vegetative screening. Article 6, Section 6.22 G11 of the zoning ordinance states adequate vegetation screening shall be required to screen the operation from ordinary public view. If vegetative screening is not sufficient, the director may require the placement of a fence or berm. Based on the evaluation of the subject property during an inspection in August of 22 and review of images in the relevant portion of this letter, the permit holder is in compliance. And again, the ordinance per section 6.22 G11 states adequate vegetative screening shall be required to screen the operation from ordinary public view. And if screening is not sufficient, the director may require placement of a fence or berm. Facts, Based on review of the images in the relevant portion of the letter from Friends of Fredenberg and review of other aerial imagery of the property, the permit holder is in compliance with the conditions in the CUP. No excavation or vegetation removal has taken place within the required property line of adjacent parcels, public right-of-ways, or public utilities. Staff determination on excavation and vegetation removal, right-of-way 175 feet, excavation from the wetland 165 feet, vegetative removal from a wetland averages 50 to 100. Permit holder has not engaged in any observable activity within 50 feet of the wetland, and the haul road is approximately 230 feet from the wetland boundary. The next one here is the aerial photo, basically showing where the excavation and the clearing has taken place. Location of where the haul road is 230 feet, and then several pictures showing the view of the properties that said that they could see the borrow pit. Number 6, in the sixth request, the applicant is merely noting that the operations have begun at the subject property. Without more, we do not see how this implicates any condition in the CUP or any provision of the zoning ordinance. Number 7 relates to whether a permit holder has a permit from the Minnesota Pollution Control Agency. Article 6, Section 6.22B3 of the zoning ordinance states it shall be the property owner's responsibility to secure necessary concurrent permits, including but not limited to the Minnesota Pollution Control Agency, state waste disposal permits, U.S. Army Corps of Engineers permits, DNR Public Works permits, or waters permits, DNR Public Waters Appropriation permits. Approval by the county does not imply approval by other agencies. Based on the information provided by the permit holder, the MPCA issued a permit with respect to the subject property with an effective date of June 2021. Thus, the permit holder is in compliance. Again, to reiterate the ordinance, Article 6, Section 6.22B3 states it shall be the property owner's responsibility to secure the necessary permits, including but not limited to MPCA, state waste disposal, the U.S. Army Corps, DNR Public Waters, and approval of the county does not imply approval by other agencies. In fact, the MPCA issued a permit with respect to the subject property with an effective date in June of 2021. Thus, the permit holder is in compliance. Then the final request relates to reclamation. Article 6, Section 6.22H of the zoning ordinance establishes minimum reclamation standards. And during an inspection conducted in August 2022, our review of the reclamation plan submitted by the permit holder in connection with the CUP and our understanding of the degree to which the permit holder has engaged in extractive use activities at the subject property. To date, the permit holder is in compliance. Again, St. Louis County Ordinance 62, Article 6, 6.22H states that all extractive uses shall implement minimum reclamation standards. Based on our review of the reclamation plan submitted by the permit holder in connection to the CUP, our understanding of the degree to which the permit holder has engaged in extractive use activities at the subject property to date, the permit holder is in compliance. And this is in regards to there being no non-working banks on the property, and topsoil, native seed, and sloping to 2:1 is not required unless there are non-working banks or the pit is in completion for the final reclamation. So we get to the BOA determination. Again, this is an appeal concerning the director's administrative determination that's set forth in this letter dated October 31st, 2022. As to each administrative determination, the Board of Adjustment may reverse or affirm wholly or partially, or may modify the administrative determination as provided in Article 8, Section 8.6B, 4, CI, and Article 10, Section 10.6B2 of the zoning ordinance and Minnesota Statute 394.27, Subpart 6. To the extent the Board of Adjustment affirms the administrative determination that the permit holder is in compliance will remain in full force and effect. To the extent that the Board of Adjustment reverses the administrative terminations, the matter will be returned to the Director for further action under Article 8, Section 8.11C of the zoning ordinance, which establishes the procedures to be followed in the event of non-compliance. The Board of Adjustment's decision concerning this appeal are subject to judicial review in State District Court as provided in Article 8, Section 8.1 E4 and 8.6C and Article 10, Section 10.6 C5 of the zoning ordinance and Minnesota Statute 394, Subpart 9. That would end my presentation. If you have any questions, try to help them out best I can.
Questions for Mark? See any Mark?
So I'm gonna have to, you're gonna have to give me a little bit. I gotta get out of this one and then another one.
Okay.
You can just click it.
That just worked.
Yeah, you can. If you want to do that, or you can just hit the arrows inside.
Thanks a lot.
Yep, no problem.
This chair and members of the board, my name's Aaron Dean. I'm a Twin Cities lawyer, but don't hold that against me. I'm not unfriendly. I wanted to come here and have a conversation. You're going to have dueling PowerPoints, but the most important thing that you have in your arsenal to decide what to do is your common sense. You have appointed positions, lifetimes of experiences. And the most important thing that I'm going to ask you to do is remember one thing. There is never a wrong time to do the right thing. There's never a wrong time. And just because other people have made decisions in the past doesn't mean you should ignore common sense. You shouldn't look at this with a set of clear eyes and a good conscience. What we're going to talk about today is how you have been put into harm's way at the board. You've been put into harm's way not by the people in this audience. You've been put into harm's way by two of your former employees, Johnson and Ms. Borbino. And they have made the wrong decision every step of the way. And as they made every wrong decision, they gained some momentum in asking the board, the county, and the judge to just follow through and just accept their decisions and for you to rubber stamp their decisions. We're asking you to apply your wisdom. There's a reason that you were appointed to these positions. You're serving the community.
I apologize for interrupting you, but at no time, I can only speak for myself, did Jenny, I have a hard time with her last name, or Matt Johnson ever approach me with anything.
I have no doubt.
And that is my own personal experience. I don't know about anybody else on the board, but I was never approached to approve anything.
That's good to hear. That's good to hear. You know, over 100 years ago, Mark Twain said something really profound that I hope you can remember. He said, a lie can get halfway around the world before the truth can get its pants on. If we're going to go through the application that was made, so you can see the lies that existed after the application and afterwards, and why you, as a board, we're asking you to step in, to intervene, to finally do the right thing, revoke this conditional use permit. We're asking for a lot. I know that. We're asking you for a lot. And I think that if you apply your common sense, if you just check. Why did this happen in the past? And just because a mistake was made in the past, should I continue to rubber stamp those decisions? All right, you already know about the 64 gravel pit. You know it's right next to it. You know it's right next to residential. It's an odd place to have the county agree to issue a conditional use permit in the first place. It's right, you can see from where we marked it, the gravel pits is kind of the lower left-hand corner. You got Fredenberg Lake, you got Island Lake. This is not the ideal location to have a gravel pit. We're going to talk a little bit more about how there were two conditional use permit applications in January of 2020 and March of 2020. And the most important thing to remember about those two applications, the applicants who submitted the applications were not the owner of the property until July 14th, 2020. The owner who received the conditional use permit wasn't the owner until over a month after the conditional use permit was issued. There is never a wrong time to do the right thing and undo the decisions that were made by your two former employees. You can see throughout this photo just how close the gravel pit will be to this lake. You know, you have a life. How many decades of experience do you have? You know this is not a good idea to be this close to a lake for gravel pit operation. We filed this appeal at the invitation of the assistant county attorney. He said to the judge, there's an administrative remedy. You have to give the county the opportunity to do the right thing. There's never a wrong time to do the right thing, which is why we are here. The county attorney told the judge that we should be here, so we're here. We've taken up a lot of your time. We're thankful for the time that you're giving us. This is very important to this community. I represent a fraction of the people who are here. I represent more of them, but they couldn't make it here. This is that important to them that they invest the time to be here before you. We have submitted reams of Government Data Practices Act requests. That's just Minnesota's fancy title for a Freedom of Information Act request. And we're going to go through what some of those documents show, because your two former employees were engaged in, I don't want to say a scheme, I don't even want to say a cover-up, but they were not telling the whole story in their written communications, in their private communications. They were saying something different. You know, there's an old saying about you learn more about a person by watching him or her on Saturday night than you do on Sunday morning. For those of you who go to church, you know exactly what I'm talking about. And we're going to look at some of those communications between Mr. Johnson and Ms. Bourbono so you can look at this and apply your common sense. You know, Mr. Lindor, he has done an able job of putting together a staff report, but you actually have the final say for the county. He's cleaning up the mess left behind by Johnson and Bourbono, and I ask that you apply a fresh set of eyes. We're asking the board to admit that other county employees, former employees, made a mistake in issuing this conditional use permit. I know how hard it is. It's hard for me to admit a mistake, particularly when my wife asked me to admit that I made a mistake. We're asking that this board admit that a mistake was made by former employees. So, you know, I know how hard this is to ask you to do this because many of you served on the commission that issued or approved that conditional use permit years ago. And I don't think many of you had the benefit of all of the information that was really relevant. Had you known the true information, you wouldn't have made the decision that you made years ago. But you're here today, still serving the community. We want you to use a fresh set of eyes to decide how to proceed. I just put down for May 18th or May 14th, 2020. It was unanimous on granting that conditional use permit. And then years later, May 18th, 2023, there were a few who decided, no, this wasn't the right idea. We need more of you. We need more of you to use clear conscience and a fresh set of eyes. My job is to show you that you have the power, not to just modify the decision by Mr. Johnson from last year. You have the power. You have the power, like King Solomon, to issue wisdom, to exercise your wisdom, to actually revoke the conditional use permit. And I'm going to hopefully explain to you why that's the right process. So, as you know, there's a civil lawsuit. Just because there's a civil lawsuit doesn't mean that you should kick the can down the road, that you should defer just to the judge and let the parties fight it out in court. The county attorney pointed out that we have this administrative tribunal to come to you. It's an awesome responsibility. You have your own private lives. We're asking you to serve in your roles for the community and as a board to revoke the conditional use permit. So the judge said, as to alleged violations of the zoning ordinance, plaintiffs, Friends of Fredenberg and Ms. Bell, have an adequate legal remedy under the ordinance. And so we went under the ordinance. This is an actual cite from the judge's decision. We have the remedy to come here, which is why we're here. I'm taking this longer, winding road to explain why we're here, so that you can vote with confidence later that you do have the power to revoke this conditional use permit. As I was preparing for today, I also looked at some of the statements made by the assistant county attorney. And he said it again in pleadings filed with the court. He said, Friends of Fredenberg, they should come here. They've got another alternative in order to seek relief, which is why we're here. County attorney agrees that we can be here as well. This is from one of the pleadings that the assistant county attorney signed. I'm not criticizing the assistant county attorney at all. He was stating the law. We are here. County attorney pointed us to be here. We're here, and we're asking you to have a fresh set of eyes on this dispute. I want to talk to you a little bit about what I see as kind of a difficulty that we all have to recognize. There's been a lot of inertia in getting to this point where there's been decision after decision against these citizens. And we saw, for example, that the city staff, the county attorney were talking behind the scenes in preparation for the last appeal, basically about don't let people talk. Let's make sure that we keep it really constrained. What they want is they want this dispute to be in a funnel. And they want everything to go through this funnel and to empty out into a garbage can where the citizens get no relief. And we're saying, no, you have the power. You have the right, according to your appointed positions, to have a fresh set of eyes. What I want you to start thinking about is as we go through your power, the zoning ordinance itself says you can reverse or affirm in part or in whole or modify any other decision that's been appealed from. We're appealing from that initial conditional use permit. We didn't have complete information at the time those applications were made. We didn't know, for example, that the applicant did not own the property. We didn't know that from 2016 to 2020, there was a problem with the septic system. We didn't know, obviously, at the time we started this, that it wasn't until June of 2022 that the county finally said septic issues were now in compliance. That's a long period of time. That conditional use permit should have never been issued. All right. You have the power to revoke a conditional use permit if there was a mistake in fact or in law, and any prior conditional use permit shall be null and void. And that's where we are. That's why we're asking you to exercise your power. So I thought it would be helpful if I just showed you the original conditional use permit application signed by LTI Holdings. Look at the very bottom. You see that acknowledgement at the very bottom? Now I'm going to blow it up on the next slide, but I'm just giving you a frame of reference. You see at the very bottom there? I want you to now take a look at it. Intentional or unintentional falsification of the application will make any approval of the application in any resulting permit invalid. So for starters, LTI said that they are the owner or the authorized agent of the owner of the property. They weren't. They applied in January 2020 and in March of 2020. I'm going to show you the deed that was recorded in the county's office. They didn't own the property until July 14th, and they recorded their deed on July 31st. The fact that they applied for this permit when they were not the owner is the easiest way for you to say, time out. We are going to do the right thing. There's never a wrong time to do the right thing. We're gonna revoke this conditional use permit. You have the authority under the ordinance to void permits issued in error. What could be more prone to error than someone representing that they are the owner, but they're really not? That's what happened in this case. We've also cited state law about all the rights that you have. For a second, just think about the common sense you have to apply. You know that you are serving this community to do the right thing. We're asking you, if someone doesn't own property and they represent that they are the owner of the property, can the conditional use permit be granted? You know the answer is no. And if you find out after the fact that the conditional use permit was granted, you know that you have the power to revoke that permit. We're also going to talk about the violations with the septic system. We're going to talk about some of the other issues that give you more than enough power to revoke this conditional use permit. But if you want an easy way to do it, permit never should have been issued because LTI didn't own the property at the time that the permit was issued. And it doesn't mean you've done anything wrong. You're following the law if you revoke that permit. There's also a requirement that there actually be inspections. And you're going to see some of the emails that were going back and forth where no inspection was performed. It's embarrassing. It's embarrassing that the county's former employees did this to you. And now you have to get the biggest broom available and clean up the mess. One of the issues in the case relates to no permit can be issued. Not only, you can't issue a permit unless you own the property, but you can't issue a permit to someone who's got prior problems until those prior problems in another pit get fixed. That's another reason why today is the day to do the right thing. There's never a wrong time to do the right thing. So you're going to see from the correspondence that Mr. Johnson, the former employee, misled everyone about conducting an inspection. And it's your job, I would present, to fix it, to step in and fix Mr. Johnson's errors. It has nothing to do with the successor. It has nothing to do with the county attorney. It has to do with problems with the former employee. It has to do with problems with the former employee who's no longer here. We all know about the reasons for his termination. We're going to talk a little bit about some of the other problems with this property.
Excuse me, sir. Again, I must correct you. Matthew Johnson is not here to defend himself. You're saying that he was terminated. We don't know that, and the county cannot release that information because that's private data for personnel. And I do wish that you would rephrase that, because we do not know that Mr. Johnson was terminated. I would like that clarified on the record, that we cannot say that.
Ms. Chair, I understand your position. Please understand that there's no retraction on our part about that. Being offered the opportunity to resign so you don't get fired is not a distinction of the difference. What I want to really focus on too is some of the prior issues made LTI Trucking ineligible for the conditional use permit that was issued in 2020, separate from the fact that they didn't own it. They didn't own the property at the time that they sought the application and at the time the county granted the permit. So they had problems back in 2008, but we McKeever pit. There's a compliance concern, and it wasn't fixed from 2008 at the time that they made their applications in 2020. That's a problem. There's never a wrong time to do the right thing, to step in and say, a mistake was made in the past and we're going to fix it. Here's the inspection report from back then. Condition 2 could be a problem, and nothing has been done. No one with authority has ever stepped in and said, you know what, putting aside Johnson and Bourbonneau, we have the responsibility now to correct errors that were made in the past. That's what we're asking you to do. Pretty obvious that they still have problems at the McKeever pit with no reclamation, still going right up to the property line. And we want to avoid a situation where that's repeated right next to a lake. I mean, the citizens who are in this room and who I represent who are not in this room, they are worried about a change in their entire life. And they're coming to you with this awesome responsibility that has to weigh heavily on your minds about how to proceed. Well, I know from looking at the documents that were produced under our Freedom of Information Act requests that Mr. Johnson failed to do his job time and time and time again. And it's time for this board to correct the errors made by its former employee. So we had asked, hey, where's the reclamation plan for that McKeever pit? And you know what? There was nothing. We couldn't find anything on the McKeever pit, and Lakehead was able to get the conditional use permit then when they shouldn't have in 2020. I want to, I'm going to skip over some of these slides, not because they're unimportant, because I want to be respectful of your time. You've got a lot to weigh on the decision that you have to make, but the most critical thing and the easiest path forward is for you to revoke the conditional use permit for the simple reason that Lakehead didn't own the property at the time that it submitted its application. One of the things that we saw on the Data Practices Act request, we'd get things like this, where JB, Jennifer Boardman, is talking to Matthew Johnson. Hey, got to follow up with Lakehead regarding the reclamation plan, reclamation activities. That's what they're saying privately, and then publicly, they say nothing. They say it's just fine, even though they don't have a reclamation. That should bother you. That should bother you that two of your former employees were doing that. You know, whether you want to call it a cover-up or negligence or anything else, it's wrong. It's wrong, and this board shouldn't stand for it. You know, as I was preparing for today, I thought, well, how am I going to explain this tortured history over the last, basically 3.5 years? And it really comes down to the buck stops here. You've agreed to these positions, and you've agreed to exercise considerable time and effort to get to the right decision. And I'm asking that you apply a clear set of eyes. Don't just rubber stamps a staff report just because someone that you trust who's a current employee has said something. How your common sense developed over decades of life experience. You know, one of the things that I saw, just as recently as April 24th, Mr. Lindhorst is asking Mr. Kineski, hey, we need an updated reclamation plan. We got these hearings coming up. They didn't have the reclamation plans at the time that was most relevant. There is an effort by the county staff to assist the permit holder while ignoring all of the requests by Friends of Fredenberg and the citizens. I wanted to show you just how troubling some of the things that have happened. I listened to the assistant county attorney basically say that there's some overlap between the two appeals. Yeah, it concerns the same property, but that's about it. Just because you made a decision one time doesn't mean you just ignore reality. It doesn't mean that you just say, I made a decision once and I'm never changing my mind. I want to show you one of the things was that they didn't have the affidavits by the homeowners in place at the time they were seeking the conditional use permit. They were required to. They didn't have it. They knew there was 3 homes on the property. They only identified 2 in their sketches to try to get the permit. One of the things that, just the easiest thing for you to do, LTI was not the owner of the property until July 14th. This shows you when that deed was recorded. It was recorded on July 1st, and it's dated June 18th, okay? And that's for the conditional use permit itself, okay? But the deed itself was signed on July 14th and then recorded on July 31st. And the conditional use permit was approved in June by the county. Conditional use permit application doesn't allow that. You only can apply for the permit if you're an owner. Here's the deed, a warranty deed from Mr. Toms to LTI Holdings, recorded on July 31st. When was it signed? Well, it's an unfair question because I know the answer. It's dated July 14th, 2020. Signed on July 14th, 2020. The easiest thing for you to do is say the conditional use permit never should have been granted because the applicant wasn't eligible to even submit one. That's the easiest thing for you to rule in favor of the citizens. Probably the most fair, and just start all over. They want to apply for another conditional use permit, then we'll have at it with the county staff and go forward. And that allows you to do your job and meet your obligations with your positions. Here's the first conditional use application. It's dated January 4th, 2020, more than 6 months before LTI owned the property. Here's the second application, dated March 17th, 2020. And I already showed you the affirmation at the very bottom when you sign it. You're certifying agreeing that you're the owner, but they weren't. They weren't the owner. And it says falsification of this application will make the application or any approval of the application and any resulting permit invalid. That's the key. Whether they were negligent, whether they lied, whatever you want to call it, what they said was untrue. The permit never should have been issued. You have the power today to do the right thing. There is never a wrong time to do the right thing. On the septic tanks, well, they knew there was a problem. LTI knew there was a problem when they applied for the permit. They knew it. I gave you the letter. One of the 2 things that I gave you. Right? What did that letter say? Date of inspection, July 13th, 2016. A land use permit cannot be issued until the applicant obtains a sewage treatment permit and installs an approved septic system. Nothing happened between 2016 and 2020 when LTI submitted those 2 applications. The property was still in non-compliance. And it's not until 2022 when the county staff says, now you're in compliance. Now you're in compliance. No do-over. The process matters. The permit never should have been issued in the first place. A land use permit cannot be issued until the applicant obtains a sewage treatment permit and installs an approved septic system. Wasn't there in 2020. That's another easy way for this board to exercise its wisdom and revoke the cup. You know, I've showed you the fact that there was a problem in 2016. Mr. Toms applied for a permit in 2016 and he couldn't get it. He couldn't get it because he had a septic problem. There has to be a consequence to not owning property and to having a septic problem. The county staff issues a conditional use permit. None of you knew about this. And now you're being asked, is there a wrong time to do the right thing? No. Today is the right time to do the right thing and revoke that permit. You know, one of the most frustrating things in life is when your time is being wasted. How many hundreds and hundreds of hours have been spent by the citizens, by the staff, and by you trying to decide what to do with this proposed gravel pit that's right on a lake? You know in your heart, a gravel pit shouldn't be located on a lake. Shouldn't be located in a residential area of the community. The easiest thing for you to do is the septic system. Rely on the fact that they weren't owners. There's many other reasons. I'm going to end up sending you this PowerPoint. If you wanted to take all the picayune minutia and find another 10 reasons to revoke the permit, fine, you can do that. But I've given you two. I've given you two that are easy, clear, understandable, apply to common sense. The permit should be revoked. I'm asking for a lot. I know it. I know it should weigh on your minds. I'm asking you to look at something fresh. I'm asking you to serve the community on the positions that you were appointed for. And it's hard, because who appointed you? You're going to have to go against him. You're going to have to go against him and be truly independent. It's hard. You trust Mr. Linden. I understand. He's doing his job, and he's already said, just rubber stamp it. So, thank you for hearing me out. There's a lot more I could say. It's taken a long time, just as Mark Twain said, for the truth to get its pants on. We're here 3 years later, more than 3.5 years after the 2 permit applications were made that were false. After the permit was issued in June of 2020. You've got the power to revoke them. Thank you.
Are there any questions? Hold on. Are there any questions? Dave?
We have had people come before us, whether it's variances and permits and such, that have not owned the property. They're in the process of buying a piece of property. They will come and they will say, you know, look, if they're going to be able to get a permit. My question is, okay, we said, yeah, a permit would be granted. If there was no activity on that permit until you say the ownership came at those later dates, how would that affect this, that they just sat, waited till the transaction went through? Would that have been a legal situation then?
There are certain clear lines that can't be crossed. Can't get remarried until your first divorce is filed. Can't apply for a conditional use permit if you're not the owner of the property. No matter what your intentions are, your subjective goodwill that you want to enter into the transaction, they signed an affirmation under oath that said, I'm the owner. I'm the owner. And they weren't. And there's nothing in the record.
I understand what you're saying. And I've seen what you've shown, and that is a legal binding situation. I'm asking our.
Can you say the question again, please?
Yeah. Where it says on that document that you have to be the owner of that property when they're coming in front of us, do they have to own it that day? The reason for this is, like I said, we've done this many times when people are looking to buy a piece of property. They say, if you'll tell me that I can have this transaction will go through.
I'm going to approach the question a different way. In hindsight, when I got up to frame some issues for the appeal, I should have addressed the scope of the appeal. And this will be a blast from the past from May. The administrative determination process here for today is the correct process for dealing with claims that the permit holder is not in compliance with their CUP or is not in compliance with the zoning ordinance. Okay? Those are the 8 items that are before you that, that they're not in compliance with respect to entrance gates, etc. It is a different kind of claim to say the CUP shouldn't have been granted in the first place. Okay? That's most of what we've heard here today, or that the CUP's null and void, it's invalid, and the board should take action to wipe it out. That is not within the scope of this appeal. I say I should have addressed that in hindsight. The reason I didn't is because I didn't think it was going to be raised. Why didn't I think it was going to be raised? I will go through the documents. The first thing I will note is that in the request for administrative determinations that the county received in September of 2022, yes, it set out Friends of Fredenberg's position that the CUP should not have been granted in the first place. However, it also said this is not a basis for the administrative determination requested pursuant to section 8.1. Okay? The next thing that happens is that Matt Johnson issues his administrative determinations. And just like he did in the administrative determinations that he issued to Ms. Bell with respect to this property, he goes out of his way to say in a footnote, just so everybody's aware, I am not issuing any administrative determinations with respect to whether the CUP should have been granted in the first place. Then we get an appeal in December of last year. And the appeal states, yes, we don't believe the CUP should have been granted in the first place, but this is not a basis for the administrative determination requested pursuant to the ordinance or for this appeal. That's why I didn't address it the first time I stood up, but it seems I need to now. You have full authority to affirm, modify, revoke the 8 administrative determinations that were made and that are before you today. The question whether the CUP should have been granted in the first place is not within the scope of this appeal.
We obviously disagree.
Don't speak.
I will give you the terms.
Yeah, so that means nothing in regards to what we're dealing with today.
The question of ownership of the property at the time that the CUP application was granted is not within the scope of this appeal. Tell me which of the 8 items, ownership of the property at the time the CUP application was granted, which of those 8 items is implicated? It's a trick question.
I know, it's not in there. It's not in there. And that's where I'm having difficulty. You're sitting here and you know what that says in black and white. Ownership of property. We're looking at this. Okay. So in reality, all we can deal with is this and nothing to do about revoking permit.
Your authority has been activated by an appeal from administrative determinations. Those administrative determinations are the 8 ones.
Yes.
That's it. You have full power to act when it comes to those things.
Yeah.
We can only act on what is before us.
Certainly.
Okay.
Mr. Chair,
Yeah.
Are you ready?
Yeah.
Are you ready?
Very ready for it.
I didn't have a stopwatch out.
Yeah.
You asked a very simple question. Does the words in the application have any meaning? Did you hear the assistant county attorney ever answer your question? He didn't answer the question. You know, if I were to take you on a tour of a cul-de-sac, we were just to drive around in the cul-de-sac for 8 hours. A lot of movement without a destination, and you didn't really have a tour of anything. I was reminded of that analogy as I listened to the county attorney tell you that you have no authority. You have the authority to revoke this conditional use permit, and we're asking you to revoke the conditional use permit. What just happened is the county attorney told the judge, we have to go in front of this board, and now he's telling the board, you don't have any authority to do anything. It's a game of playing, when you flip a coin, it's no different than me telling someone I flip a coin, all right, you call it, but I'm gonna tell you right now, here's the rule of the game. I flip the coin, heads I win and tails you lose. No matter the outcome of flipping that coin, you lose. That's what the county attorney just said to the citizens, that you are been appointed to serve. No matter what they do, they lose. That's not the outcome. We're asking you the two easiest ways to revoke this conditional use permit: septic for line, ownership for line, and you can go on the other 8 issues that we've raised in our papers. Any one of those 10 reasons are easy to revoke this conditional use permit. Please don't kick the can down the road and make this another federal problem. Please intervene. If you revoke the conditional use permit, guess what happens? LTI, they get to apply for a new conditional use permit. We'll be there. We'll be able to explain why it shouldn't, as of 2023 or 2024, whenever they're there, why they still haven't met all the conditions. We're not asking you to deny them any opportunities. They'll have their opportunities, but we'll be there to meet them. Thank you.
Are there any other questions? Thank you. It was a very good presentation. I appreciate it. Yeah.
Just one more word. In response to the notion that I've engaged in some type of double dealing and telling the board one thing and telling this board or any citizen something else. In the district court case with respect to this property, I've said this before, it's a distinction, I'll say it again. There were 2 kinds of claims made in that case. One, the permit should not have been granted in the first place. 2, the permit holder is not complying with the CUP or the ordinance. Okay? What I told the judge and what the judge ruled is that that type of claim was made too late. The judge agreed. It's been dismissed. This type of claim needs to go through the administrative determination process. I've been consistent on that point throughout. The district court's decision reflects that distinction. I have never said, Mr. Dean knows this, I have never said that the right way to raise the claim that the permit shouldn't have been granted in the first place is to come through this process. I have never said that because it's not correct. So I just wanted that to be clear for the record.
Thank you. Okay, do I have a list over there? Okay, Charles Knappner did that one. Clayton Sitch, are you in the audience? Would you give your name and address for the record, please?
Clayton Sitch, 4955 Vista Bay Drive, Duluth, Minnesota, Fredenberg County.
Would you like to stand and give your testimony?
I will.
I'm just gonna put back the other one so we get.
Okay.
That's all I'm doing.
The computer.
It's still morning. Good morning. Anyway, we've been at this for a while. Some familiar faces here. And I know at the last couple of hearings that I've been up here for, it was always being made of suggesting that you folks had no power to do anything, which I find a little curious. Why would we even show up here? But apparently there is power here. And I think I can't say anything more than has been said already. And this is the wrong place for this pit, and things have been done wrong. And it's cost us all a lot of time, effort, and families' money. And they're not looking forward to the other operations that the same company has. 70 years, that's a big portion of how long the United States has actually been in business. And that's what they're looking forward to now in the same location. 70 years, maybe, the same thing. And who knows if it gets so bad and the pits look so bad, maybe there'll be more pits in the area. But that's not the reason that people are living on these lakes and enjoying their futures. So.
Thank you, Mr. Sitch. Ole Olson?
Thank you. Ole Olson, 4931 Fish Lake Road in Fredenberg.
Mr. Olson, if you need to sit there, that is fine.
You know what? I think I need to stretch out. Thank
Okay.
you. Thank you, board members. So I'm here to just speak to one of those items that were spoken of in there that you read about there, and it's I can speak to it because I work for the LTI Holdings. Go for them, I know exactly how things go there. But I live within a golf ball's drive for me to the property where this gravel pit's gonna go in. My 6 grandchildren, my beautiful bride Janet, and our children, they don't want this. They come out here, they come out to our place for peace and quiet, serenity, no noise, there is noise because there's already a gravel pit pretty darn close to us, across the highway from where this one's going. So, you know how close that we are to this property, and on the compliance issue on the septic. I'll tell you what it is. I told this to the Board of Commissioners 2 years or more ago. That septic system, my dog, red and white English setter, was nothing but wanting to hunt all the time. And I don't know what she was after. It was an otter, because they do pass between our lake and Fredenberg Lake. But that dog took off and I couldn't stop her. And I went inside, I got the shock collar dealio, you know, that we have on hunting dogs. But trying to stop her was too far away already, you know, it was already too far away. So I had to hop in the car to go around looking for her. Went down Fredenberg Lake Road, and I'm right in front of Tom's property, and I got out of my car, And the Towns' property, this is where the gravel pit's going. Hit the shock collar, and that dog felt it. Felt it really well, and here she comes. That red and white dog now was completely black. Because whatever she was chasing went down into the septic area where all this raw sewage gets dumped in. And she comes up completely black and smelling like WLSSD does some days. It was really bad. And I had to clean that crap out of her. I didn't know I had to put her in the back seat of my car to get her home and go wash her up. That's not a compliant septic system. You know, ours is compliance. It's got the drain field. It's good. For every property that gets sold in St. Louis County, the property has to have a compliant septic system either before the closing of the property or within 60 days after. They can put a contingency in the purchase agreement and it gets done. I had two of our daughters that bought properties and the septic system they were buying was not up to date. They had to get a mound system put in and it was taken care of.
I'm getting off track here. You're talking about septic system.
Yeah.
And we're talking about this couple.
Right. Exactly. Thank you. It's the septic system not being in compliance. Turn your dog black. That makes this cup invalid. They gotta have something. They gotta have a mound system put in. I know they're not cheap, but it's just the way it is. It's just the way it is. For all of the citizens, but all of a sudden when there's a company involved, well then, forget about it. Who cares about their septic system? So please, just follow the rules. It's right there in the guidelines of the county. What the different 5 of them that have to be met to approve a cup application. This one had one that it met. Not all 5. So, and the only one it met was because there's already gravel pits in the area. We got enough dust already.
Madam Chair, I got a question from Mr. Olson. Mr. Olson, what year was that this happened with your dog?
It would have been, let's see, 19? Yeah.
2019?
Yeah.
And you're aware there's a new septic system been there for a couple of years already?
Been told that, but I don't believe it because it sure looks the same. Remember,
Okay,
we live right there.
thank you.
I don't think anything's done.
Thank you.
You would notice if it was done, that there was activity. Anyway, thank you very much.
Mike Anderson.
Mike Anderson, 6456 Open Drive.
Would you come to the podium? Sir, could I ask you your address again?
6456 Olson Drive. I got property right next on the other side of where the cup wants to go. And I would say we're more like a stone's throw. That property. I think that one thing that really struck me was from the talk today is they're trying to avoid a problem that has existed for years. And I think growing up, as long as I can remember, I'm almost 70 now, and the McKeever pit has always been the McKeever pit. Just have that one in such need of reclamation, in such need of repair. When we don't feel like guidelines are being followed, and really looking closely at all the requirements and things that you need to follow, to see that that one's in such violation, it just really makes us wonder, you know, really concerned about it. And it just seems like it's time to make things right. Thank you.
Thank you, Mr. Anderson. Next is Bruce Anderson.
Bruce Anderson, 4929 Fish Lake Road. In Mr. Lindhorst's facts and findings, I thought it was interesting that he didn't speak to not being compliant on a current cup. He didn't speak to any of that non-compliance on a current cup in his facts and findings. This is a tortured history. I was here at the very first meeting, the March 12th, 2020. We were sitting over here, the board was sitting over here at this time. What just stands out like it was yesterday is after, I believe Todd Koneski gave a reason why they want to mine there, because of all the sand.
Sir, to address the board?
Sure. I like to include everybody, my neighbors and friends.
No, you're speaking to the board.
Yes, I am. I'll never forget, like it was yesterday, Commissioner Nelson turned and he said, sand. We need sand. Sand. We need sand. I think it stopped that day. Rubber stamp. Sand. We need sand. I think it stopped. It was such a clear rubber stamp. I was there that day. I was also attending the Zoom meeting, May 14th, when the cup for 6464 was approved. Talk about frustrating being in a little room you can't see you folks. It's so different when you're on a screen. It's good to be presenting in person. That's the day Mr. Scraba, who's now a representative, he was on this board, sat here. He was so frustrated. He said, we want facts, not emotion. Facts. Folks, you got facts. Laced now with emotion. I sat on several more meetings. I sat in on Melissa Bell's appeal, where Mr. Campanero basically hijacked the meeting. Hijacked her meeting that she paid a lot for, not only time, but financially. I sat in this room when you awarded LTI a cup extension for asphalt reclamation, knowing there's in violation already. Since you didn't think it would do any harm, you said, by golly, you got this. It's okay to reclaim asphalt. That's like a misbehaving child and say, come on in, it's time for a candy bar. Here, help yourself. They were awarded that. Not only severe reclamation issues, public safety issue, which Mr. Campanero agreed could be a problem. But like he likes to say so much, this is not within the scope of this appeal. We're talking about an undermining public safety snowmobile trail. But since it's not within the scope of the appeal, I'm tired of hearing that one. It's a tortured history. To err is human, to blame someone else is politics. Hubert H. Humphrey. I have been to many, 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 haven't missed very many, commissioners' meetings. where I've asked them, like Mr. Dean stated this morning, this is a tough decision. It's tough to kind of backtrack. I have asked that board many times, untangle the web. We're all adults. Untangling a nasty web is very difficult. It's very difficult. But is it right to move on in the wrong direction knowing you have all these facts and findings? And that this was issued in error? Please, please do the right thing and rescind this cup. I asked you at the last meeting, please take your facts and findings. Don't rush into this. You have 35 days. Boom. You approved it. Please do the right thing.
Thank you.
And rescind the cup.
Bonnie Anderson?
I pass. I pass.
Okay. All right, there's nobody else on the list, but is there anyone else in the audience that would like to speak? Thank you. Donald, do we have anybody online?
We do. We did make an announcement on the chat, but I'll do it one more time here. Anyone online that's wanting to submit some testimony on this case, please raise your virtual hand and then we'll call on you. First, Angie, can you please unmute Matt Anka? Matt, you are unmuted if you'd like to provide testimony.
Hello, can you hear me?
Yes, could I have your name and address for the record, please?
Yes, Matt Hanka. I'm with the Freiberger Law Firm in Duluth, 302 West Superior Street, Suite 700. And I'm one of the attorneys that works with Lakehead.
All right, you may proceed, sir.
Thank you. I'll be brief. My hope was just to observe today, but things went a little sideways, I think, with Mr. Dean's presentation in which he's attempting to challenge the cup. So I simply want to reiterate exactly what your attorney has advised you on, and that is that all of the discussion about the issuance of the original cup is irrelevant, pursuant to the ordinance, and is outlined in both the appellant's appeal letter itself, as Mr. Campanario outlined, and the staff report. This board is tasked with reviewing the specific 8 complaints that were outlined in the appeal letter. That is the focus of this board's review. The original decision on the cup stands. As Mr. Campanario outlined to you, that was litigated in the courts, and it was dismissed. The staff report here goes through the 8 actual complaints in detail. You heard that presentation. No violations were found. And so we are simply asking that the board follow the staff's recommendation and approve the director's findings of no violations. Thank you.
Thank you, sir. Anyone else, John?
Yeah, I'm going to try one more here. Angie, can you please unmute call-in user 2? And I see no other virtual hands at this time.
Thank you, Donald. With that, I'm going to... Yes, you may, but stand and give your name and address.
My name is Ann Sitch, 4955 Vista Bay Drive, and as you know, I've been coming a long time. Look at me and look at the people in our neighborhood. We are older and we want to enjoy the rest of our life. We don't want to hear the beep, beep, beep of trucks all day long and the dust in the air, and we have to close our windows because in the summertime and the spring, because the dust is coming in, then you have more work to do. We have a beautiful community, hardworking people with beautiful homes. I can't see how, in good conscience, you think it would be okay to put this pit there for 10 hours a day, 6 days a week with all their noise and the trucks hauling and going. We're a beautiful community. This pit doesn't belong there. It's not even that big an area to destroy the lives of so many people every day. It's just good common sense. Don't do this to your citizens who pay very high taxes to live there. I'm sorry. I just can't believe this is going on this long and you can't get the full picture here. Thank you.
Can you stand and give your name and address, please?
My name is Deborah Johnson. I live at 4438 Cary Road. I, for 30-some years, lived at 6350 Beaver River Road in Fredenberg. And we had a pit that was put in. We had local zoning then. And through massive intimidation, the pit was put in. And it was right across the road from me. And we had a beautiful, right on a hill, it was beautiful. And that changed our life forever. The pit is still there. My daughter lives at that address now. And I cannot tell you the dirt that you couldn't open your windows and the noise. They would start their diesel trucks at about 4:30. This is year round. And as you know, that's vibration. And you're laying in bed and you get woke up with zzz, and it goes for hours until they start. And then the backup beepers start. And then the thing. And I would call when the dust would get so bad and at the county, because I truly thought you guys cared about the citizens. The county did. So when I would call and say, they're not using the water, the dust is just, you can't go outside. And they would say, you know what? Just write the date down and what they're doing. And, you know, at the end of the year, hand it in. And I was like, so you're not going to send a water truck up? And they're like, oh, no. And it was, and that is just the way, and we just learned that, but it wrecked, and it really did. It was, I mean, I actually came close to losing my faith because I couldn't believe that God would allow something that was egregiously, it was again, a pit put right in with residential. It was horrific. And the only way I think that anybody should vote for a pit to go into residential is if you live there, buy one yourself that you're not benefiting from, you know. But I have my faith. And even if you do vote to let this pit go in, God's still in charge. But I really cannot tell you, I cannot explain to you the depth and the continuation. It goes year round. I foolishly thought it was going to start, you know, stop in the summer, after the summer it didn't. And then to put it on top of that, our lovely road planning department, they came along and they fixed the road before us, the Beaver River Road, and they needed gravel. So I did have a lovely buffer, huge trees right across the road. They took them down, they clear cut them, took the whole thing because they wanted the gravel. And so they took it down. So, and I said, my gosh, I can see the pit. I can see the pit now. There was no buffer for me. And they said, don't worry, in 2 years, because we're up on a big, I don't know if any of you go up there, it's a big, high, windy road, it goes back down. A lot of people go in the ditch in the winter. We're going to take it down, so you know what, you're not going to see anything, because we're going to do this and that for you. I think she's 30, how old are you, 39? 39. She was probably about 5 then. And it never happened. So I finally went to the board there, asked to talk to who was in charge of the roads. And a man came out, and I don't know who it was, but a man came out, and he said, come here. And he brought me between the 2 doors. You know how they got the double doors? He brought me there. And he looked at me, and he got a smile on his face, and he laughed at me. And he said, oh, that road, that's never happening. He said, we changed the parameters of what will meet the need for a road to be redone, and you don't fit anymore, and you never are. And then he laughed, and he walked back in. And I was literally devastated that first I get a pit, and then I lose my buffer, and then I find out that this is the way it's gonna be. So I just want you guys to really understand, this is not a NIMBY. I hate NIMBY, I really do, I do hate it. It's not good, so.
Jamie Millennius, 6350 Beaver River Road. I bought my parents' property. I was born and raised there. We have a pit right across from us. Grew up with that. But I also want to be clear on something. You know, I'm a safety manager for a construction company. I'm also part of the Iron Mining Association. I've been to the mines around here. I work safety. I mostly work safety for oil and gas. So I work with big oil. I travel a lot. I travel across the country. And when I come home, you know, home is home. And yes, I was, you know, used to the gravel pit at home. I always thought maybe there'd be an end to the gravel pits at home, but I think the more I see, I've never seen a gravel pit really closed and reclaimed around the area. But I guess one thing I just want to be really clear on is, like my mom said, we're not NIMBYs. I'm used to the pit there, and I like gravel pits. I work with gravel pits all the time. In fact, I'm an MSHA instructor. I'm an ultra instructor. I give MSHA classes. I give 24-hour MSHAs, 8-hour MSHAs. Like I said, I go into US Steel. That's what I do. I know mining, and I like mining. I think it's actually essential to our community. I think most people understand the need for mining. I understand the need for gravel and sand, so I'm not against it. And I live right next to a pit. I'm not against it. But I also think, as a safety person, I'm also for the rules. And that's what I do. I mean, you know, there's rules and there's black and white. And that's kind of where I see this a little bit. I don't mind the pit next to me, actually. I'm kind of over it. But, you know, as long as he follows the rules, it gets better for me, I guess, you know? But another pit in the neighborhood, and they're not even following the rules to start with, I just see some problems there with that. So I'm a rule follower. Like I said, I like mining, I like construction, but I just think the rules need to be looked at here and followed. All right, thanks.
Thank you. Is there anyone else?
Can I say one thing?
You may. You can say it if you'd like.
Oh, I can stand it. You know, I love
name and address.
I'm Janet Wilson, 4931 Fishlet Road. I love what Mr. Dean had to say. It's pretty simple. It shouldn't have been granted. You know, it just shouldn't have been granted. We all agree that gravel pits are necessary, but not in a community. And what I think what isn't really showing up is there's not just one lake. There's 3 lakes real close.
We understand that. You know? We've seen that.
Okay.
And it's been said.
Okay. And so I'm thinking it makes simple sense just to do the right thing. They can apply for a new pit, or, you know, or a new application. Let them do that. Let's start over. But they weren't in compliance. Nothing about that was right, and it should have never gone through. So please, 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 we are begging you just to do the right thing. Thank you.
Is there anyone else? Once I close the hearing, there will be no interaction with the audience. Hearing closed. Got some discussion?
Yeah.
Well, my biggest problem is I don't know who the friends of Fredenberg are. That's my biggest problem. To me, it's like an anonymous complaint. I know we hear everybody from the audience, but their attorney said paperwork. It's in paperwork. We have it written down. These are the 8 things that they brought up. The attorney tells us this is what we have to follow. This is what was sent out in a packet to all the surrounding residents. So this is what we have to go by, are these 8 things. Does anyone else have anything?
Madam Chair, I'd like to make a motion.
Okay.
I'd like to make a motion that we should exercise our option under Article 8 of the ordinance to postpone the resolution and hearing for 35 days or until the next public hearing as the planning department schedule. And I'm not certain how that would be presented because under the ordinance we're required to render our decision in writing. Not sure if that means or could mean the result can be in the minutes of the meeting or not. But at any rate, I would like to postpone our decision for up to 35 days as our option under the ordinance.
Is there, Tom?
I want some discussion, or are you waiting for a
No,
second?
well, he made a motion, but we can also have discussion before we find a second for it. We don't have anybody for second right now.
Couple of days. I don't know when this was originally submitted, so I don't know if the 60-day rule will overlap on the 35 days, and if whether it did or didn't. What would 35 days give us?
Well, I think that I've got some questions that I need the planning staff to answer, and I'm sure that others might have questions also.
I guess what I'm getting at is, this is basically what and I shouldn't say put them together, but I looked at them from months ago and to this one. They're in the ballpark. They're pretty much the same. There's not that much fantastic new information that popped up. And so I'm just wondering, I mean, there was Mr. Dean or someone said, why keep kicking a can down the road? Well, this to me would be kicking the can down the road, regardless if it's voted up and or down, but 35 more days just allows a few more kicks of the can.
I think, go ahead.
Your motion, as long as we can do it, I will be seconding. But what creates a problem for me is, okay, it's going to give us 35 days. It also gives the opportunity that I see this part that's in here about, that was brought up about that it couldn't possibly be done. It's not legal. That can be pursued at any time, any way they want to do that. And then it can become mute anything in 35 days. I just, right now, our options, it makes no sense to me to just do something on this at this moment because I just don't understand what we're there. I have many different questions that keep popping up. If you didn't say what you did, I was going to say, can't we just table this? Okay, that's what we're really doing. But I don't understand the deal about the court dismissed what in regards to this. I heard that last speaker say this was dismissed. I don't understand what was dismissed.
Okay, can I have,
yeah.
Nick, I saw you. Did you want to say something?
Yeah.
I don't, one member inquired about the 60-day rule. The 60-day rule doesn't apply to this appeal. The rule that we have to hit is that the decision has to be made within 35 days of the date that this hearing is closed, which is today. Practically speaking, there is another Board of Adjustment meeting within 35 days of today.
The next meeting would be October 12th, which is 21 days.
So your question was about something different.
Well, I'm trying to understand that one of the last speakers said something about the court dismissed.
Correct.
What dismissed what?
What Mr. Hanka was referring to was the district court's dismissal of the claim that the cup shouldn't have been granted in the first place. And again, as we've discussed before, that was dismissed on the grounds that it was, you have to bring it in a certain place within a certain time under state statute, and they failed to do that.
So that argument about the ownership and such is mute? It wasn't done in a timely manner? Is that what you're saying?
Correct.
So that has no relevance.
I hope that I've been clear on that so far.
That's even more confusing to me. Now, we see that you have to have ownership at that time, but they didn't bring it in a timely manner, so it's irrelevant.
It's not relevant to the appeal before you, which is limited.
Okay, we're going back to that again.
Yeah, so you understand it. You might not, I mean, you might not.
I know
push
us.
back on it, but I think you do understand it.
I hate this. This belongs with lawyers and judges.
I understand though that, I've listened to everybody, I've tried to give everybody enough time to speak, but the fact is that all we can do today as this board, no matter how much power anybody thinks we have, is the 8 items that are listed. Is that correct?
Correct.
So it doesn't matter what anybody else is bringing in. That is what we have to deal with, are these 8 items.
Correct.
Thank you, Nick.
So we could delay it, if you don't want next month, but next month, it's still just the 8 items. We're not bringing 12. I mean, we're just administrative appeal was concerning the 8 items. Correct. We're not going to just show up in 21 days and 13 items. It's still going to be the same 8 items.
Exact same thing, and that's all we can look at is what's there. So do you want to make your motion official?
Yes.
Okay, and Dave, did you say you wanted to second it?
I'll second it.
I'm going to call it for a roll call, please. Donald, would you do roll on it, please?
And this is to postpone till October 12th hearing date, correct?
Okay.
Which would be the...
Is that, it will be postponed until October 12th. That's soonest and the latest that we can hear it.
Is there a second meeting?
Not as of now.
Okay.
Yeah, that's fine.
Okay. Board members Spatos.
Support.
Chair Warshay.
No.
Board member Flipovich.
Support.
Board member Pollock.
Support.
Board member McKenzie.
Support.
Board member Kuhn.
No.
Board member Manick.
Support.
Motion passed. The decision will be made on October 12th. Okay, is there any other business we need to take care of, Donald?
I have no other business.
Do we have a motion to adjourn?
So moved.
Second?
Before we second, this is raised. Have not before we adjourn.
Yeah.
Like rock. Okay, I'll second.
Okay. All those in favor, aye.
Aye.
Meeting's adjourned.